Law cannot differentiate between Hindu, Christian, Muslim, or secular cruelty in diverse cases, according to Kerala High Court. The court explicitly stated that it is not in agreement with the theory that what constitutes cruelty to grant divorce can be different for persons belonging to different religions. For more information, we shall move to inside the video. I kindly request all the viewers to watch this small video in full. Now we shall go to inside the video for further information. The Kerala High Court recently held that matrimonial cruelty to justify divorce must have a uniform definition regardless of personal law. Mary Margaret versus George P. Thomas. A division bench of Justice J. Muhammad Mustaki and Sophie Thomas said that law cannot recognize different varieties of cruelty based on religion regardless of the fact that personal laws include or exclude certain definitions for cruelty. The court also drew inspiration from Article 44 Uniform Civil Code of the Constitution to arrive at this conclusion. Law cannot recognize different varieties of cruelty as Hindu cruelty, Muslim cruelty, Christian cruelty, or secular cruelty to justify a decree for divorce. The mere fact that Hindu Marriage Act and the Special Marriage Act refer to cruelty without any rider or explanation, or the fact that the Divorce Act and the Dissolution of Muslim Marriage Act give indication of the nature of matrimonial cruelty that ought to be established cannot justify the conclusion that the nature of matrimonial cruelty which would entitle the spouses for divorce is different under different personal laws, the court said. Significantly, the court explicitly stated that it is not in agreement with the theory that what constitutes cruelty to grant divorce can be different for persons belonging to different religions. We discard the theory that the concept of matrimonial cruelty to entitle a spouse for divorce can be dissimilar and different for persons belonging to different religious faith merely because different words are used in relevant personal law statutes, the judgment said. Law cannot recognize different varieties of cruelty as Hindu cruelty, Muslim cruelty, Christian cruelty, or secular cruelty to justify a decree for divorce. According to Kerala High Court, therefore, the court opined that matrimonial cruelty must have a uniform definition to justify the founding of a decree for divorce. Under Section 10, subsection 1x of the Divorce Act, the cruelty must be such as to cause reasonable apprehensions in the mind of the petitioner, suppose that it would be harmful or injurious for the petitioner to live with the respondent. However, the expression harmful or injurious cannot be limited to physical harm or injury, the court said. Anything that would hinder the ability of the spouse to blossom into his her fullness and to enjoy life in matrimony must be held to fall within the sweep of Section 10 subsection 1x of the Divorce Act. Cruelty, which is not defined in Section 13 subsection 1a of the Hindu Marriage Act and Section 27 subsection 1 of the Special Marriage Act, and cruelty, which is explained in subsection 2 8 of the Dissolution of Muslim Marriage Act and Section 10 subsection 1x of the Divorce Act must all take inspiration from such understanding of matrimonial cruelty, the court further said. We discard the theory that the concept of matrimonial cruelty to entitle a spouse for divorce can be dissimilar and different for persons belonging to different religious faiths merely because different words are used in the relevant personal law statutes. Kerala High Court. The court passed the judgment on an appeal filed by a wife against the degree of the family court which had granted divorce on the husband's application on the grounds of cruelty and discretion against her. The couple had married as per Christian rites and ceremonies in 1998 and had two daughters before the husband filed for divorce in 2009, which was granted by the family court in 2015. The main allegation of the husband was that from the inception of marriage itself, his wife exhibited behavioral disorders which often turned violent and abusive. He also argued that his wife was inattentive to the children and that since 2005 she lived at her paternal house and ignored their children. Pertinently, he continued that even though the wife had been taken to various psychologists and psychiatrists, she did not cooperate or complete any course of treatment. The appellant wife, however, stated that the allegations made by the husband were false and that she was ill treated by him and his mother. It was that ill treatment which caused mental stress for which she consulted doctors she contended. For the High Court, the main consideration was what can be construed as cruelty in the confines of matrimonial life, which it opined has to discerned on a case to case basis. Cruelty can be physical and mental. Physical cruelty provides more of a direct evidence that it can be perceptible when compared to mental cruelty. Mental cruelty can be drawn from the facts and circumstances of the case, whereas physical cruelty can be drawn from the conduct of one spouse towards other spouse which endangers the other spouse's physical health, the court said. The court primarily relied on the judgment of the Supreme Court in Samar Ghosh versus Jaya Ghosh, which elaborately discussed the nature and scope of mental cruelty as a ground of divorce. The top court had also observed that the concept of mental cruelty cannot remain static. It is bound to change with the passage of time, impact of modern culture through print and electronic media and value system, etc. etc. What may be mental cruelty now may not remain a mental cruelty after a passage of time or vice versa, court said. In the instant, the court noted that even the daughters of the couple had testified in support of the allegations of cruelty made by the husband. Further, a psychiatrist that the wife had consulted also testified that she suffered from an impulse control disorder, but that the appellant had not completed her treatment. Therefore, the court held that while one may suffer from mental stress or strain due to very many reasons, not taking treatment for the same in order to bring out a peaceful and a harmonious family atmosphere also may have to be counted as cruelty. In these grounds and on consideration of the fact and circumstances of the case, the court dismissed the wife's appeal. Hello viewers, if you are liking this video means kindly press the like button as well as share to your friends and relatives. I kindly request all the viewers to subscribe this Aravindar Annai Arul channel. Moreover, I thank you for your valuable time spent for watching this video. Your response has been highly appreciated. Once again, thank you very much.